Hello everyone, my name is Scott Aubrey. I am the owner of Aubrey Law. We are an estate planning law firm, and I'm very happy to be here with you today. And today I'm going to talk about the basic estate plan. What are the elements of a basic estate plan? But before we get started, if you have any questions about what I talk about today, or any questions about estate planning in general, you can go to estateplanmeeting.com and schedule time to talk with me for free. Again, estateplanmeeting.com. Go to that website. Pick a time that works best for you, and I'll be more than happy to help you in any way that I can. So today's topic is what are the basic elements of a estate plan, or what goes into a basic estate plan? So estate planning really helps you in two different circumstances. One, while you're alive but incapacitated, and then secondly, what happens after you die. So the first instance is that while you're alive but incapacitated. So what that means is that you're unable to communicate with others, so you can't really express your wishes. So what you really need to help you and to protect you is you need to have powers of attorney. And there are two types of power of attorneys. One is a medical power of attorney, and then two is a financial power of attorney. So for medical power of attorney, what that is, you appoint an agent, and they are able to make medical decisions on your behalf if you're unable to communicate with your doctor. So if you're incapacitated, your medical durable power of attorney will come into effect, and that person will act as your agent. They'll talk with the doctors and and decide what is the best decisions to make regarding your medical treatment. The other power of attorney is a financial power of attorney, and that is someone you name as your agent, and they are able to make financial decisions on your behalf. That would be paying bills, maybe making selling a business, whatever the case may be, whatever powers you give to that person, they'll have that ability to make those decisions if you're unable to communicate yourself. Another thing that you need during incapacitation is an advanced medical directive. And that's really what happens, what you want to happen for your end-of-life decisions. Do you want to have a respirator? Do you want feeding tubes? Things like that. You make those decisions now, and then then your healthcare agent will then hopefully follow those when the time comes. The only caveat with advanced medical directives in Massachusetts is they're not legally enforceable or legally binding. So what that means is that you can't go into court and have someone enforce that, or doctors don't have to follow that. The healthcare proxy or your healthcare agent will be the one making decisions regarding your medical decisions that will override any sort of advanced medical directive that you have. And then the other circumstance where an estate plan comes into play is upon your death. And that's probably the very common thing that you know about estate planning is that's a will. And what a will does is the first thing it does is it names a personal representative that will be responsible for settling your estate. What that means is they pay your bills, they effectuate the transfer of your property to your beneficiaries, who you name in your will you want to get your properties. If you have minor children, your will name your long-term guardian for your minor children. And also in your will, you can direct certain bequests or gifts that you want to make to people upon your death. You know, if there's a certain watch you want to give to someone or a certain property, whatever that may be, you can put that in your will. So if you don't have any of these documents, if you don't have a will, if you don't have a power of attorney, then what you need to have is need to have court intervention, or the courts will need to get involved and make these decisions for you. If you don't have a powers of attorney, then the court will appoint a guardian to look over you while you're incapacitated. They may appoint a conservatorship to look over your finances while you're incapacitated. So really what comes down to, if you don't have those power of attorney, then the court makes that choice for you. And that choice can take a little more time. You don't have the choice of who gets to be appointed your agent, so that could be anybody. The court deems to be the person the best suited to carry those roles. So if you don't have those things before you're incapacitated, then the court steps in. Same thing happens if you don't have a will. Then what happens is that certain decisions are made for you. Number one, how your assets are distributed. They are according to the state intestacy laws. So basically, the court or laws of Massachusetts will decide who gets your property. If you have minor children, the court decides who will be the long-term guardian of those minor children. You don't get to make that decision for yourself. So it's important to have a will because it allows you to make decisions now, so the court doesn't have to get involved in the future. Also, if you have a will, things can be a little easier with the probate process. Again, those are the basic parts of an estate plan. One would be a will that covers you for what happens after you die. And then two, there'd be your powers of attorney, which covers you while you're incapacitated. The other thing that some people include in the basic estate plan is a trust. And what a trust can do is it allows you to have some control over when your beneficiaries receive your assets. I think this is really important if you have minor children, because what will happen is if you were to die before your children turn 18 and you only had a will, all the assets you leave to them will be put into a trust and be overseen by a guardian that's appointed by the court. And what will happen is once they turn 18 years of age, they receive those assets outright. So there's no sort of restrictions. They'll be able to use those assets wherever they want it to be. So if you want to have some control, or maybe then stagger when they receive those assets, if you want to make sure they use those assets for education or buying a house or things like that, then you really need to have a trust in order to do that. So think of a trust as more of like a backpack, in that during your lifetime you put assets into this backpack, and then when you die, that they seal up that backpack, and then you appoint someone to oversee those assets in that backpack, and they have to follow and they decide when your beneficiaries receive those assets and things like that. So your trust, it's really important to have a trust if you have minor children, something to really consider as part of your basic estate plan. And so the other thing to really consider when doing about estate planning is that you have to do this today, and that these things cannot be done after the fact. So you cannot wait until you're incapacitated to be done, or obviously you can't wait until you die. So really, the thing about estate planning is that it needs to be done today, and it can't be done at a later date. So again, the basic parts of estate plan are a will, your power of attorneys, advanced medical directives, and also considering having a trust there as well. Again, my name is Scott Aubrey. I'm the owner of Aubrey Law. If you want to talk to me about estate planning, you can go to estateplanmeeting.com and schedule a time to talk with me for free. Again, estateplanmeeting.com. You'll see my schedule. Pick a time that works best for you. I'd be more than happy to help you in any way that I can. If you like this video, please hit the like button. If you want to hear more from me about estate planning, go to estateplanmeeting.com. Again, you can leave a question or comment if you want to. If you know someone that can benefit from seeing my video, please forward this to them. Again, I'm Scott Aubrey. I'm the owner of Aubrey Law, and I will talk to you soon.